Hello and welcome to this extra special recap of week 6 of the Trump trial. Is this trial finally coming to a close? Let's discuss. Let's find out. We ended last week with Trump's former attorney and fixer Michael Cohen still on the stand undergoing cross-examination. So we started this week with more of the same on Monday. Monday morning saw more politicians vying for the warm embrace of a Trump administration position, making statements outside the courthouse and showing solidarity with Trump in court by wearing the same blue jacket, white shirt, red tie combo that Trump always wears. It is creepy and it is cultish. Also, Chuck Zito, the ex-president of the Hells Angels New York chapter, was there to support Trump as well. Like, there is some mob shit going on, okay? Allegedly. So Cohen was back on the stand Monday morning for cross-examination. Remember, up to this point, the defense has been attempting to paint Cohen as a fame-seeking, Trump-obsessed simp who would say anything to get Trump put in prison and did the whole Stormy Daniels deal of his own accord with no input from Trump. And also that he's a big fat liar, or at the very least couldn't possibly remember the level of detail he's testified to, given that he was incredibly stressed, overworked, and received literally hundreds of calls a day during the time period around the Stormy Daniels payoff. So cross-exam on Monday morning continued with more of the same, getting Cohen to testify that he was extremely busy and distracted around the time of the payoff, that the Daniels issue wasn't the only fire that he was attempting to put out. On Monday, Cohen also discussed stealing from the Trump Organization. This was mentioned in direct examination, but the defense decided to really get into the details, again, because it shows that he's a liar and also willing to go behind Trump's back, which supports the defense's argument that Cohen did this all on his own. Along with reimbursement for the $130,000 Stormy Daniels payoff, Cohen was reimbursed for what he claims was a $50,000 payment he made to a company called Redfinch in order to get them to cast phony votes in an online poll about who the most famous businessman of the last half century was. Trump was polling at the bottom, which, like, holy shit. $50,000 would be a life-changing amount of money for most Americans, and Trump's fixer was paying that to massage Trump's ego in an online poll. And even with the payment, he only made it to number 9? Are you fucking kidding me? These people. Anyway, Cohen said that he actually paid the Redfinch exec only $20,000 of that $50,000, which he kept in a brown paper bag. The details in this trial are rich, wild. It's just painting the most sinister, sleazy picture of what sounds like a New York mob crime ring. Money in brown paper bags, Trump avoiding email because that's how other people get caught. It's frankly breathtaking. Anyway, Cohen paid the exec $20,000 in cash in a brown paper bag and then told Trump he paid $50,000 so that Trump would reimburse him, and Cohen pocketed the difference instead of paying Redfinch the full $50,000 that he'd promised. And he did this because, remember, in 2016, Cohen's bonus got slashed by 2/3 when he thought that he was going to be seen as a hero for orchestrating the Daniels payoff. So Cohen was pissed. All right. He usually, apparently, got $150,000 for his bonus, but that year he only got $50,000. Must be rough. The defense also, through its questioning, made the argument that Cohen built his name off the back of Trump. Cohen testified that he made over $4 million off his book sales, another $4 million in consulting fees that he earned after Trump was elected from companies who, I guess, paid Cohen to tell them about Trump? I don't know. Consulting is fake to me. No offense. So yeah, his ties to Trump made him millions and millions of dollars. But in his testimony, Cohen claimed, "My name recognition is because of the journey that I've been on. Is it affiliated to Mr. Trump? Yes. Not because of Mr. Trump." All right, buddy, sure. The defense also focused heavily on the fact that Cohen in the past has never had the Trump family on any sort of retainer agreement, even when he's done legal work for them. So the fact that he wasn't on retainer in 2017 doesn't necessarily mean that the monthly payments he was receiving were actually reimbursement and not payment for ongoing legal services. The absence of a signed retainer doesn't mean he wasn't continuing to do legal services for the Trumps in 2017. And in fact, he testified that he was doing legal services for the Trumps that year. So labeling the payouts as legal services wasn't fraud, it was the truth, according to the defense. And what I think is interesting here is the defense is saying that Cohen is a liar and a perjurer, but only when he's talking about the reimbursement payments. Clearly, he cannot be trusted because he's lied in the past and he's lying now. But when he says that he made millions of dollars on his book sales, when he says he lied about the Redfinch payment, when he testifies that he's never had the Trump family on a retainer, there he's clearly telling the truth. They're cherry picking what the jury should believe, that sometimes he's telling the truth and other times he's a liar. The jury could very much find that actually he was telling the truth the whole time. Yeah, he's made tons of money on his relationship with Trump. He stole money from Trump. He never had the Trumps on retainer. And also, the Stormy Daniels payment was a reimbursement and not payment for legal services rendered. That frankly seems more believable to me personally than that he's up on the stand cherry picking when to tell the truth and when to lie and somehow managing to keep his story straight for years. That's just me. The defense then wrapped up cross-exam and the prosecution had the chance to do redirect. On redirect, they can only talk about issues that came up on cross-exam. So it's an opportunity for the prosecution to kind of clean up the narrative. The prosecution confirmed again that Cohen did not bill the Trump family for any legal work in 2017, that the payments he received that year were all reimbursements for the Stormy Daniels payment, because again, the defense tried to insinuate that Cohen did legal work for the Trumps that year, so the labeling of the payments as legal fees wasn't incorrect. According to Cohen, at least, he didn't bill the Trumps for anything. Those were reimbursement payments. The prosecution also took the opportunity to remind the court that Cohen is not the one on trial here. Yeah, he's sleazy. Yeah, he's a convicted perjurer. Sure, he just admitted on the stand that he stole money from Trump, but whatever, This is about Trump, okay? And then after nearly 4 full days on the witness stand and 17 hours of testimony, Cohen concluded his testimony on Monday afternoon. In total, the prosecution called 20 witnesses over the course of 15 days. After Cohen left the room, Assistant District Attorney Joshua Steinglass told Judge Marchiony, "Your Honor, the people rest." All right. After the prosecution rested its case, no time was wasted, and the defense began their case by calling its first witness, a paralegal named Daniel Sitko, who works in Trump's defense attorney Todd Blanche's law office. And this is a common thing, to call paralegals so that they can testify as to the contents of the evidence that they sifted through or work that they did related to this case. And this paralegal was tasked with creating a summary chart of phone calls between Cohen's phones and attorney Robert Costello. And I imagine this was just meant to set the scene and the timeline for the defense's next witness, Robert Costello himself. Remember, last week Cohen testified that after he was raided by the FBI and pleaded guilty to numerous charges, Trump put up a huge barrier wall between himself and Cohen, chiefly through only communicating with Cohen via Rudy Giuliani, who would then talk to Robert Costello, who would then talk to Cohen. And Costello would use code words like "my friend" to refer to Giuliani and "my friend's client" to refer to Trump. Very sketchy. Anyway, that's the guy the defense called to the witness stand Monday afternoon. However, before he could take the stand, the prosecution asked for a bench conference. The jury was dismissed so that the lawyers could discuss out of earshot of the jurors. The prosecution argued Costello shouldn't be allowed to testify at all, but if he does, he shouldn't be able to opine on Cohen's credibility, which is exactly what he was there to do. Costello very publicly has said that Cohen is full of shit and not credible. However, the defense countered that Costello was there to rebut the prosecution's claim that he was part of a Trump scheme to keep Cohen from ratting on them. Costello even testified before the grand jury that indicted Trump in this case and claimed to have given testimony to undermine Cohen's credibility to the grand jury. The judge ruled that he would allow the defense to question Costello about specific statements in Cohen's testimony and offer some rebuttal, but he wasn't going to allow this to become a trial within a trial as to whether or not there was a scheme between Costello and Giuliani and Trump and how it affected Cohen. So then Costello was able to take the stand, and he testified that Cohen told him numerous times that Trump knew nothing about the Daniels payment and that Cohen did the payment on his own. Costello is a former New York federal prosecutor, and he's friends with the likes of Giuliani and Trump. So he very much fits into this sleazy New York mob narrative that this whole trial has painted. And he exhibited that during his testimony by regularly continuing to speak even after objections were sustained, speaking over the judge. Remember, this is a former federal prosecutor. and making aggressive comments under his breath every time he was cut off. At one point, the judge, who I've heard reporters say has been very measured and reserved and fair this whole trial, the judge got so mad that he made the jury and reporters leave the room so he could admonish Costello. The judge is quoted as saying, "Mr. Costello, I want to discuss proper decorum in my courtroom. If you don't like my ruling, you don't say, geez, you don't give me side eye, and you don't roll your eyes." And when the judge was met with a prolonged icy stare from Costello, that's when he really had it, saying, "Are you staring me down right now? Clear the courtroom right now. Clear the courtroom." At which point, all the jury and the reporters were shoved into the hallway. And then the judge dealt with Costello, and then afterwards everyone was let back in, and his testimony continued, though defense attorneys urged Costello to keep his answers concise, and the prosecution made many objections, most of which were sustained by the judge. The defense had Costello confirm that he never put pressure on Cohen to do anything, meaning he never pressured him not to rat out Trump. After a little over half an hour, the defense ended its questioning of Costello around 3:30, and the judge ended court for the day, with Costello's cross-exam to begin Tuesday morning. And after the jury was dismissed for the day, the defense made a motion to dismiss the case immediately, arguing that the prosecution failed to prove their case and there's absolutely no evidence that the business records were false. The judge seemed unmoved, but said he would decide the motion to dismiss later. This is pretty common for the defense to do. There are times throughout the course of litigation when the defense has the opportunity to make motions for the judge to dismiss the case for varying reasons, because the prosecution hasn't made enough showing that they have a claim or they haven't proven their claim. And the defense has to take these opportunities to make these motions to dismiss, because if they don't take them, they lose them. And then even on appeal, they can't bring that issue up unless they make the motion during the litigation phase. One time for them to make this motion is after the initial lawsuit is filed. The defense can move to dismiss, saying that the state hasn't even alleged anything that amounts to a crime. And then after the discovery phase, when all the evidence has been collected and shared between the sides, they can move to dismiss again, saying there's nothing here that amounts to a crime. And then after the prosecution rests its case, the defense can move again to dismiss, saying, look, we've seen everything that they have. As a matter of law, they have not met the burden of proof of the required elements of this crime, so much so that it's not even worth sending it to the jury. So it's annoying, but it's the defense's job to take advantage of these opportunities to move to dismiss the case whenever they can. The judge also confirmed that closing arguments would be scheduled for the Tuesday after Memorial Day, May 28th, so next week. With the holiday weekend, it was just easier to schedule it out to after the holiday rather than try to shove it in and risk being in the middle of closing arguments when they had to break for a long weekend. Trump, of course, left the courtroom and immediately had to run his mouth, telling reporters that the judge is a tyrant and Costello is highly respected. And he called the trial a disaster for our country. So that's how Monday wrapped up. And Tuesday continued with Costello cross-examination. The prosecution opened Costello's cross-exam on Tuesday with emails between Cohen and Costello, especially ones in which Costello repeatedly dangled his close ties with Giuliani and Trump in front of Cohen's face to try to get him to bite. Costello was better behaved than on Monday, though he repeatedly tried to add extra detail and context where the prosecution did not ask for it. And the prosecutor had to repeatedly be like, no, that's not right. Let's move on. No, thank you. Like Costello repeatedly tried to take every opportunity he could or create opportunities for himself to say over and over how much of a liar Cohen was. And this was really not the behavior of a disinterested professional attorney. This seemed like a man with a vendetta in a way that actually ended up making Cohen look all the more credible. Like, oh, you think Cohen's bad? Wait till you get a load of this fucking guy. You know what I mean? Anyway, Cohen claims to have never hired Costello. There's too many names in this. Though Costello repeatedly said Cohen should hire him to represent him after the FBI raid. In emails presented on cross-exam, the prosecution showed Costello communicating with a partner at his law firm in which Costello said, "Is he totally nuts? He's playing with the most powerful man on the planet." Clearly annoyed. The prosecutor asked if Costello was mad at that point because he had lost control of Michael Cohen for the president. Did you not? To which Costello replied vehemently, absolutely not. Again, the prosecution's narrative is that Costello was working on behalf of Trump to keep Cohen in line so he didn't rat on Trump. Very mob boss per usual. Costello and the defense are saying, no, Costello was just innocently trying to help Cohen out. There was no scheme here. But cross-exam did not last long. At 9:15 a.m. on Tuesday morning, the prosecution finished its cross-exam of Costello, who left the stand. And at 9:17, Trump's defense attorney Todd Blanche declared, "Your Honor, the defense rests." So turns out we won't get that Trump testimony after all, which frankly would have been a fun show to watch. The jurors were sent home at 9:20 a.m. that Tuesday, and they won't return to the courtroom again until Tuesday of next week when closing arguments are set to begin. The judge suspects that closing arguments will take a full day, and then the judge will need at least an hour to give jury instructions. And the court isn't in session on Wednesdays, and it was already canceled for this past Friday because of juror conflicts with the holiday weekend. So the only day left in the week this past week for trial to happen would have been Thursday, which likely wouldn't have been enough time to do closing arguments and jury instructions. Plus, the case would have then been turned over to the jury, who would then go on vacation for 4 days before starting deliberations. That's too much space between closing arguments and jury deliberation. We want the case to be as fresh in their minds as possible and to avoid any confusing cutoffs during closing arguments. So the jury was dismissed for the whole week and will come back on Tuesday. This past Tuesday afternoon, after the defense rested, the attorneys and judge held a charging conference, which is when both sides and the judge hash out exactly what will be in the charging document, that's the one that the jury ultimately fills out with their decisions, and what's in the jury instructions, which is when the judge tells the jury before they go into the deliberation so that they can fully understand the law, because they have to be able to apply the law to the facts of the case to make a decision about whether or not the prosecution proved every element of the case beyond a reasonable doubt. And the jury doesn't have to decide generally whether they believe beyond a reasonable doubt that Trump is guilty. They have to go step by step through the elements of the crime he's been accused of, and for each element, decide whether they believe beyond a reasonable doubt that the prosecution proved that element. And they have to do that for each of the 34 counts. Each side can submit their proposed jury instructions, and then the judge ultimately decides exactly what the jury will be told. And this conference, this charging conference, can get down to word-by-word discussions. For example, at the beginning of the charging conference on Tuesday, the defense wanted to add the word willfully to a couple of the jury instructions, which the prosecution argued wasn't necessary. The word willfully has a legal meaning that can be hard to prove, and this entire case is hard to prove because it hinges on Trump's knowledge and intent. Did he know it was going on? And did he intend for the mislabeling of the reimbursement as legal fees to cover up the underlying crime of affecting the outcome of an election? The jury is going to have to decide this based on circumstantial evidence. There isn't a smoking gun recording or written communication where Trump said, hey, let's pay off Stormy Daniels $130,000, make Cohen do it, then reimburse him, but call it legal services in the book so that no one will ever find out that we paid Stormy off because we wanted to affect the outcome of the election. We don't have that. Instead, we have testimony from people like Daniels, her attorney, Cohen, and Hope Hicks, saying things like the Trump campaign was in chaos after the Access Hollywood tape leaked. They knew that statements against Trump brought by women would harm his chances of winning the presidency. They paid Stormy off as part of a larger scheme to cover up these stories. Trump was obsessive about finances, so he knew where every penny was. Anything Cohen or CFO Alan Weisselberg did had to go through Trump first. Here are phone calls between Cohen and Trump days before the Stormy payoff. Cohen says Trump knew about it, et cetera, et cetera. And in all of that, the jury has to decide, okay, has this added up that we can make the inference that they have proved each of these elements beyond a reasonable doubt? And a lot of the back and forth during the charging conference had to do with how to instruct jurors about campaign finance law and campaign contributions. Because, for example, if Trump had just paid Stormy Daniels off himself with his own money directly, he probably would have been fine. Even if it was meant to affect the outcome of the election, that's okay because candidates to a federal election are allowed to make financial contributions to their own campaigns. This would have probably been fine. We also learned a new word during the charging conference. 𝗪𝗏𝗪𝗍𝗪. 𝗪𝗏𝗪𝗍, which means relating to or dependent on charity or charitable. The judge himself admitted he had no idea how to pronounce it, so he decided to strike it from the instructions, which I thought was goofy. There were also discussions about accessorial liability, meaning when a person can be found guilty for actions taken by someone else. In this case, the idea is that Trump can be found guilty even if he didn't personally write down legal services in the company's books. Now, liability has many layers in both criminal and civil law, and I'm not going to get into it, but here it probably has to do with the level of control that Trump exerted over the people under him in the company, and the likelihood that, because of his actions, the falsification was an obvious outcome. Like, for example, if someone hooked up jumper cables to an electric box to steal electricity, that person would be guilty of the extra charges made by the utility company, even if that person didn't personally write down those charges and add them to the bill, the utility company did. It's an obvious outcome that if you steal electricity, the utility company will add those charges to the wrong bill. So basically, how are we going to instruct the jury as to how they should figure out whether or not Trump is guilty, even though he didn't personally write legal fees in the company's books? The defense also argued in favor of including an instruction that just being present in a room when others agree to something doesn't necessarily mean that you're guilty of a conspiracy, which the prosecution argued would just confuse the jurors because Trump isn't accused of conspiracy in this case. And especially in regards to a meeting in 2015 when Trump was in the room with Cohen and National Enquirer CEO David Pecker, where they agreed to a catch and kill scheme, that instruction would just paint that meeting as just some benign gathering as opposed to letting jurors decide what happened based on the testimony. The judge did not make a ruling either way on that one. And the conference ended with the judge admonishing the defense. They tried to bring up that they needed to add a jury instruction that would basically say Trump was acting on advice of counsel when he acted because Cohen was his lawyer, so Trump thought it was legally sound to pay Stormy Daniels off. The problem, however, is that the defense decided months ago that it wasn't going to use this defense known as the advice of counsel defense. Basically, my lawyer told me to do it, therefore I thought it was legal. The problem with taking that defense is that it requires you to drop attorney-client privileges and turn over to the prosecution specific documents that otherwise wouldn't be available because of attorney-client privilege and other rules. So the defense can't have given up that defense and then turn around and say, we should tell the jury who was acting on advice of his counsel, because they didn't also sacrifice the attorney-client privilege or all the other things that come with that defense. They just keep trying to slide it in there under a different name. So the judge called the defense disingenuous and ended the conference by telling them not to bring it up again. Now, we won't know the exact jury instructions until next week because the judge is the one who ultimately decides this. But just as a refresher, Trump has been accused of 34 counts of falsifying business records. Under New York law, a person is guilty of falsifying business records in the first degree when he makes or causes a false entry to be made in a company's business records and does so with an intent to defraud, including intent to commit or hide another crime. So when proving a case, it's typically broken out into multiple elements, and each one must be proven by the prosecution beyond a reasonable doubt. Here, based on the language I just gave you, again, we'll see what the judge ultimately decides to give the jury for instructions, but the prosecution has to prove that, 1, Trump caused a false entry to be made in his company's business records, and 2, he did that with intent to hide an underlying crime. The prosecution does not have to prove that the underlying crime was committed. Trump is not being prosecuted for fraudulently influencing the outcome of the election or campaign finance violations or anything, at least not in this trial. The prosecution just has to prove that Trump intended to cover up the underlying crime. So they have to prove he knew what he was doing and he meant to do it because he didn't want the public to know about the underlying crime. And that he did this 34 times. And that is each falsification of business records that they found, either, the checks to Cohen that he signed or the notation in the company's books. So the jury has to go count by count and see if they believe beyond a reasonable doubt that he's guilty of each element of every count. So they have a big job ahead of them. Again, closing arguments, also known as summations, will be held on Tuesday next week. The defense will go first this time, and then the prosecution goes last. And this gives both sides the opportunity to go over what the jury just saw and connect all the dots for them, or poke holes in the argument in the defense's case. And the judge said the case could be turned over to the jury as early as Wednesday next week. So there's a very real chance that we could have a verdict next week. We'll see. Depends on how long the jury needs for deliberations. My personal prediction, based on zero powers of clairvoyance and having not been in the courtroom, so don't hold me to it, is that we'll get a hung jury. There's going to be a mistrial. The state won't have the time to retry Trump before the election in November. And if it is a hung jury, then jury deliberations might take a while. But only time will tell. All right? I'll be back next Saturday to go over summations and who knows, maybe a verdict? We'll see. Have a great holiday weekend. Bye-bye.